Hello guys, this is Olayemi Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law, where we'll be talking about the part 2 of my class on the doctrine of privity of contract versus consideration. The doctrine of privity of contract versus consideration. In my last class, I went through the whole explanation for you. I made you understand why we talk about the doctrine of privity and why we talk about what? Consideration, right? I made you understand the rule also in relation to a gratuitous beneficiary and all that. But in this class we are looking at the cases. Last class we're talking about the rules, right? We didn't talk about the cases. I just made you understand the rules. Today we'll talk about the cases. And like I said in last class, we are talking about 3 cases. The case of Dunlop Pneumatic TYRE Co Limited versus Selfridge Limited, and also the case of Scruttons Limited versus Midland Silicons Limited, and also the case of Beswick versus Beswick. So we have 3 cases to discuss today, and in each of these cases I'm going to walk you through the rule of privity and consideration and what is the mentality of the court. Do you understand? We've spoken about 2 cases before, Price and Easton, Tweedle and Atkinson, and we're able to talk about the mentality of the court, right? In these cases we'll talk about the mentality of the court in relation to consideration. But if this is your first time of coming to my channel, then I want to say a very big welcome to you. Thank you so much for coming to my channel. Please make sure that you click the subscribe button. Also make sure that you click the notification bell so that anytime I release a video like this, which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Also, do not forget to share with your friends and your colleagues and the people you know that are going to be in need of this particular video. And lastly, don't forget to follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniel. Thank you so much as you do so. So now let's go to our first case. Our first case of what? Dunlop Pneumatic TYRE Company Limited versus Selfridge International. Lord Haldane said something beautiful in this case. So let us quickly go to the case. Now we have Dunlop, who was a tire manufacturing company. So now Dunlop was a tire manufacturer who agreed with their dealer to not sell the tire below a recommended retail price, RRP. As part of the agreement, Dunlop also required their dealer to gain the same amount with their retailers, who in this instance was who? Selfridge. The agreement held that if tires were sold below the RRP, they would be required to pay £5 per tire in damages to Dunlop. This was agreed between the dealer and Selfridge, which effectively made Dunlop a third party. This should be noted, which effectively made Dunlop a third party to the agreement. Sometime after this, Selfridge sold the tires below the agreed price, and Dunlop sued for damages and an injunction to prevent them from continuing this activity. At the initial trial, the decision was given to Dunlop. This was appealed by Selfridge and the decision was reversed. Then Dunlop further appealed. So in year 2, which you are right now, you should know that there are 3 tiers of court, so to say. You have the trial court. There are more. I'm just letting you understand. We have the trial court, which is usually the state high court or the federal high court. Now I'm talking in context of Nigeria. Then you now have the court of appeal. Then after the court of appeal, you now have the Supreme Court. So when you hear that at the trial court, what happened at the trial court? That's at the initial trial. Dunlop won, abi. Then when the other party, Selfridge, went to the court of appeal, who won? Selfridge won. Then Dunlop now what again? Appealed to the Supreme Court. But in the context of England, their own Supreme Court is what? House of Lords. Our own here is Supreme Court. Oh yeah, now let's go back to the class and let us even understand the fact. I told you that when you are reading, there are 3 things that you must read: fact, issue, and judgment. So now the first question is, what is the fact? The fact is that Dunlop manufactures tires. Do you understand? Now we have a particular tire sold by Dunlop, and Dunlop told his dealers, hey, come here. You see this tire, one like this now, 1,000 naira. don't sell it below 1,000 naira. You don't hear? The dealer said no problem. He now told the dealer that, you see, when you further sell it to your retailers, you must sell it for 1,000 naira. Don't sell it below 1,000 naira. The dealer said okay. So let's say the dealer is Jasco. Not that according to the fact, they did not tell us that the dealer was Jasco, but I'm just telling you that the dealer is Jasco from Papa Jasco. So now the dealer Jasco now went to Selfridge. Selfridge is a retailer, and then Selfridge now wanted to buy the tire, and then the dealer told Selfridge, that's Jasco told Selfridge, Dunlop told me that it is 1,000 naira, that I should not sell it below 1,000 naira. And then Selfridge said okay, no problem. Then in the contract, I told you to notice earlier, in the contract, in the event that the retailer sells it below 1,000 naira, what's going to happen? The retailer will pay Dunlop, listen to that, £5, right? But let us say 5k, 5,000 naira. Are you listening? In the event, look at the rule in the contract. Now look that contract was between who and who? Jasco and Selfridge. Jasco the dealer and Selfridge. You know there is a contract between Dunlop and Jasco, right? That one is a separate contract. But there is another contract between Jasco and Selfridge. Now Selfridge agreed that he was not going to sell the tire below 1,000 naira, right? If he does, then he will pay damages of how much? 5,000 naira to Dunlop. But who is Dunlop to that contract? Did Dunlop make offer? No. Did Dunlop accept? No. Did Dunlop furnish consideration for the contract? No. But Dunlop was mentioned as a third party, which means that Dunlop is privy to the contract, but Dunlop did not furnish consideration, which was the issue. Now Dunlop now wants to sue Selfridge. That's why the case is what? Dunlop versus Selfridge. Who is supposed to sue? Jasco. But Jasco is not suing. So Dunlop wants to sue Selfridge for the subject matter of the contract that Selfridge had with who? With Jasco. Do you understand? And that contract which Selfridge had with Jasco, Dunlop is saying that my name is stated in the contract, and it was stated, which you agreed, it was stated that in the event that you sell it below 1,000 naira, you will pay me 5,000. See, you have sold it below 1,000. Oh yeah, my money. And then Selfridge said, well, I don't know you. I did not make the contract with you. The person that I made the contract with is Jasco, and it's only Jasco that can come before the court. So let us go to the issue. What was the issue? Selfridge argued that Dunlop could not enforce the contract as Dunlop was not part of the agreement between the dealer Jasco, and Selfridge. On this basis, the question for the court was whether Dunlop had the right to access damages without a contractual relationship. Now, what did the judge say? The court held in a unanimous decision that Dunlop could not claim for damages in the circumstances. The court found that, firstly, look at this, only a party to a contract can claim upon it. Listen to that. Only a party, a contracting party. Is Dunlop a contracting party? No. Dunlop is a third party that was mentioned, a jus quaesitum tissue. And if you are a jus quaesitum tissue, you cannot what? You cannot enforce a contract. Secondly, Dunlop had not given any consideration to Selfridge and therefore could not have a binding contract between the parties. Not only was it that Dunlop was merely mentioned as a third party and not a contracting party, Dunlop had not furnished what? Any consideration to Selfridge and therefore could not be a binding party. Then lastly, Dunlop was not listed as an agent. Now this falls under the exceptions. One of the exceptions which I will teach you when I'm talking about the exception. Dunlop was not listed as an agent within the contract and therefore was not included as a valid third party who had the right to claim on the contract. Don't forget that in my first class when I was teaching you the introduction, I told you that there are exceptions to this rule. I told you that some of the exceptions are gotten from the common law and some of the exceptions are gotten from statute, and I told you that don't worry, that in my later classes I will teach you these exceptions, right? But right now, what are we trying to get? We are trying to get the general rule. So when it gets to the exceptions, I will tell you that. But something that Viscount Aldine said, which is very important to us, he said, my lord, in the law of England, certain principles are fundamental. One is that only a person who is a contracting party to a contract can sue on it. Only a person who is a contracting party who has made an offer or who has accepted the offer or who has furnished consideration can what? Can sue on it. Our law knows nothing of jus quaesitum tissue. Third party, I keep keep saying that. Our law knows nothing of jus quaesitum tertium arising by way of contract. Such a right may be conferred by way of property. That's another exception, but I will talk about that later. So this is Viscount Haldane, what he has said in the case of Dunlop Pneumatic Tyre Company versus Selfridge. So we now go to our next case, which we'll be talking about again. Do not forget that the dissenting view, what Lord Viscount Haldane said, gained traction and was adopted by the House of Lords in Scruttons Limited versus Midland Silicon and in Beswick and Beswick. So what happened in this Scruttons Limited versus Midland Silicon? Now, a drum filled with chemicals and shipped from the United States to the United Kingdom was agreed by a bill of lading, which included a clause which referenced the United States Carriage of Goods by Sea Act of 1936. This clause limited the liability of the carrier to $500 for any damages that was caused to the goods. The carrier engaged stevedores to deal with the unloading of the cargo on arrival, and unfortunately, while lowering the chemical drum into a lorry, they negligently dropped the drum, causing almost 6,000 worth of damages. The respondents sued for the loss, but the stevedores claimed that their liability should be limited as per the clause stated in the contract. Now, I want you to understand that there are three people here. The first person is the person that wants to transfer, drums that has chemical from US to UK, right? I need you to understand what is going on here. He wants to, let's say there is chemical in a drum, benzene or something. He wants to transfer it from one place to the other. And those drums are huge, heavy, and they are a lot. So he now contracted with a carrier. Do you understand? That's the ship. The carrier is the ship. So the ship company, there was an agreement that in case anything happens to this drum, we, the carrier, will not be liable so far it's not up to $500. Do you understand? If it's not up to $500, we will not be liable. And if it's more than $500, we will deduct $500 from it. And do you understand all those kind of things? Now, when they now decided to carry that particular drum, there was no problem. Now, don't forget that the contract is between who and who? It is between the owner of the drum, right? And the carrier, that's the ship, right? Now, the ship, they now contracted people known as stevedores. Stevedores are those people, they are like people used to carry things. When you go to my 12 and all that, and you have goods, this thing, you see all these aboki, in our own context, all those aboki that used to carry things, those people are known as stevedores. So the stevedores now began to offload, listen to me, they now began to offload the drums from the ship. There was no problem on the ship. The drums landed safely at its destination. Now that means that the contract of the ship and this thing is concluded. That's the carrier. Now, when they now got to the domots, they now say, come and carry your thing. Then the stevedores now started carrying it. Then they negligently fell it down, which then caused loss of about $600. So what now happened? Stevedores now say, well, there is a contract, we will fall under the contract. There are two things that we need to ask here. Were the stevedores, were they even mentioned in the contract? There are two things. You must be mentioned, but mentioned as a third party, right? And therefore, you must have furnished consideration. That's the rule that we are working with. But this one, let us look at this Silicon's case. This one not even they mentioned. Where the stevedores even mentioned, let's look at the issue. The overriding issue for the court to consider in this case was whether the clause of the contract, which was inserted by the United States Carriage of Goods by Sea Act, could be relied upon by the stevedores who had damaged the bottle. It was particularly important for the court to consider whether the stevedores were party to the contract between the buyer and the seller. What was the judgment? The court held that the clause could not be relied upon by the plaintiff, and the plaintiff there are the stevedores, as the United States Carriage of Goods by Sea Act did not apply to stevedores. But let us even not look at that. Moreover, the stevedores were not a party to the contract by Look at it. By express or implied terms between the parties. I love what the judge said. By express, they were not a party. They were not a party means they were not even mentioned. They didn't even mention you. It's just like that case that I painted to you earlier. TYRE and Shubomi. Shubomi went to buy phone, iPhone 13 Pro. And TYRE, that was not mentioned at all, is now in court. You were not mentioned. Talk less of say you want to furnish consideration. That's what the judge said here. The judge said that they were not party to the contract by either express. They were not expressly stated as parties, or they were not impliedly stated as parties. So you know that there are two thresholds, there are two hurdles. Number one, you must have been stated. Then number two, you must have furnished consideration. This one, the Steve does, they were not even stated in the contract between the ship carrier and the owners of the drum. You know, it is in that place that you now have the whole liability clause that says, oh, £500, right? Now, you are not even stated there in the contract, neither expressly or impliedly, and you are saying that you want to rely on it. Who are you? They were therefore what is known as what? Strangers to the contract, and the court relied upon the fundamental principle that the stranger cannot rely upon a contract they are not party to. Can you see it? I think this case is easy. It's simple. In the first case of Dunlop and Selfridge, what happened in that case? Dunlop was mentioned in the contract between Jasco. Don't forget that it's me that named it Jasco. Is what? Dealer. Dunlop was mentioned in the contract between the dealer and Selfridge. It was mentioned. It says in the event that Selfridge sells below the price, what are you supposed to do? Selfridge will pay Dunlop 5,000 this thing, but there it was $5. Oh, but me, I'm just saying it, 5,000 naira. Abi, that was stated. So Selfridge was privy. It was a party. Do you understand? Although a third party, not a contracting party. But the court then said that you cannot, because what? You have not furnished consideration. Do you understand? But this one, Silicon, you know, they don't even mention you. Nobody know your dad. They don't mention you for there. And you call the talk say you won't come under the contract. No, now. Wrong. Wrong. Do you understand? So let's go to our last case of Beswick and Beswick before we end our class for today. Now, in the case of Beswick versus Beswick, PB was in poor health and agreed with the defendant, his nephew, that he would transfer the trade and goodwill of his co-business to him on the basis that the nephew employed him as a consultant for the rest of his life and paid him for this. The nephew also agreed to pay PB's wife after PB died for the rest of her life. She was not a party to the agreement. Upon the death of PB, the nephew paid PB's wife once, but then not again. PB's widow brought an action as administrator of PB's estate and also in a personal capacity, claiming for specific performance. Now, the issue is that PB's widow raised two interesting questions for the court to consider. The first was whether the widow as an administrator of PB's estate could claim for an order of specific performance for PB's nephew to honor the agreement. That's one. And number two, it was also important to see how the court weighed this claim against her claim on a personal level, which was that she was a party to the contract between her husband and the nephew. Now, what did the court say? The court held that the damages would also not be limited due to the loss that has been caused to PB's estate. However, the court found that PB's widow could not claim under personal capacity as she was a third party to the contract and not a party to the original contract. The only thing I want us to get from Beswick and Beswick is what? When PB is the owner of the trade, right? He was about to die. He was sick, obviously, and he knew he couldn't continue. Then he told his nephew, come here. This is it. I will give you my trade. Do you understand? And I want you to carry on with this trade. But you are going to be paying me every week so money. Do you understand? And I'll be a consultant. If you have any problem, come and meet me. I am in a consultancy level, right? But I will not be active, right? Now, I want you to pay me so money. And if I die, pay my wife. Now, the wife has been mentioned. Therefore, the wife is privy. Pay my wife so money till she dies. Now, when he died, the wife now came and said, oh yeah, money. He said he's not going to give. Then the wife came under two heads before the court. The first head, as per administrator of the estate of the man. I already explained that to you. When someone dies, he puts in an administrator or an executor. So the wife was coming as an administrator, and also the second head was as on the personal level as privy to the contract. Because she was privy, she should be able to collect her money which was supposed to be paid. The court held on the fact that you are the administrator, yes, you have the right to collect money, but on the fact that on the personal level that you are privy to that contract, no, you are not privy. So Beswick and Beswick further support what we have been saying since. I would like you to also read two other cases. We have the case of Kepong Prospecting Limited versus Smith and New Zealand Shipping Company Limited versus AM Satterthwaite and Co., also known as the Eurymedon's case. I want you to read these two cases very importantly, and in my next class I want us to discuss Nigerian cases. But one of the things that we need to get in this case is that when you are talking about privity, there are two things that must be noticed. Two things. Number one is what? Number one is the fact that the person must have been mentioned. In Silicon's case, the person was not mentioned. In Dunlop's case, the person was mentioned. In Beswick's case, the person was mentioned as party. That is third party. But the attitude of the court, you know what I said in last class, is that so far the person has been mentioned, then in order for us not to have injustice by having double consideration from the person mentioned, consideration from the other party, because of double consideration and the injustice that it will cause, the court should allow that person mentioned to collect the benefit accrued to him. That was my own submission. But when we look at these cases, we will see that the court does not agree with my submission. The court is saying not only must you have been mentioned, you must have also furnished consideration. But these are all these Oyinbo courts. Now let us come down to our own Nigerian court. What is the perspective of our Nigerian judges and justices to this, doctrine of privity of contract? Do they align with me or do they align with the Oyinbo judges? We will discuss that in my next class. Thank you so much for watching to the end of this lecture. Please don't forget to like this video and comment, and also do not forget to share with your friends and colleagues that you know that are going to be in need of this video. Don't forget to follow me on LinkedIn and on Instagram. I will see you in my next class.